The death penalty is supposed to be awarded in the rarest of the rare cases. Could you tell us what that means?
The test is not only that the case has to be the rarest of rare, it's a two-part test. So the first is the death penalty will be awarded only in the rarest of rare case, and the second part is that the alternative option is unquestionably foreclosed. So it will be given in the rarest of rare case where the alternative option is unquestionably foreclosed. Rarest of rare is a case that is, as the word goes, in the most extreme category. It is very seldom seen, and it ticks all the parameters of heinousness, depravity, perversity, cruelty. So that is one element. It's rarest of rare. The case is rarest of rare. But also the person who is being given the death penalty, he too must exhibit, both in the crime as well as in his life, otherwise, the most extreme perverse traits so as to merit the death penalty and have his life extinguished. His role in that particular crime must also be in the most extreme category. So that would take care of the rarest of rare case. And the second part, which says where the alternative option is unquestionably foreclosed. So even if a case comes into the rarest of rare, even if the prisoner falls into the rarest of rare category, he can only be given the death penalty if his case forecloses the alternative option. That the alternative option, which is the option of life imprisonment, is unquestionably foreclosed. There cannot be any debate about that life imprisonment is a wholly inadequate sentence. So both tests have to be satisfied. Now this was a test laid down in 1918, Bachan Singh's case. But thereafter, because of developments in the law, it's actually now become alternative options. Because whereas in 1980 you just had a single alternative option, which is that of life imprisonment, you today have multiple alternative options in terms of quantified life imprisonment. You may have, with a minimum of 20 years, 25 years, 30 years, or even 40 years of full life. So now the question is whether the alternative option of full life, where you keep him in jail for the rest of his life without any possibility of release. In such a case even, can you say that this punishment would be wholly inadequate and unquestionably inadequate? Only then can you say that the alternative option is unquestionably foreclosed. So this is the test in law. It's a two-part test.
What is the single most important reason that you oppose the death penalty?
I can't stand the thought of a person being killed in my name. I am completely opposed to violence. Violence by anybody is wrong. Killing is completely wrong. Whether the killing has been done in anger, whether it has been done calmly, or whether it's been done as a part of a conspiracy for terrorism, for gain, for lust, it doesn't matter. Killing is wrong, except for self-defense. There is no other justification for killing. So the idea of killing somebody, especially the way we do, after calm, rational, cool discussion, deliberation in a courtroom, and then procedures which are set out in law, submission of mercy, clemency, petitions. After that, in that calculated manner of killing, according to me, is the worst form of killing. It is even worse than the form of killing, done by murderers. Because here you have done it so premeditatedly. And after thinking so much, with the aid of law and procedure.
Why shouldn't people who have committed such heinous crimes be subjected to the highest form of penalty? Don't the victims or the families of the victims deserve justice?
So let me answer this in two ways. Let's just look at the families of the victims deserving justice first. You have about 35,000 homicides in a year, and out of which ultimately 3 to 4 get the death penalty. So is it anybody's case that the 34,996 family members did not get justice just because the killers did not get the death penalty in those cases? Just because somebody does not get the death penalty, does that mean that justice has not been done? Where do you get that from? So, as I say, 4 out of 35,000 get the death penalty. So the other victims have also lost a family member in the homicide. can it be said that justice has not been done to them as per law? That's the first part. Now, as regards the other question, why shouldn't people who have committed heinous crimes be subjected to the highest form of penalty? Certainly, if it's the most heinous crime, give them a strong punishment, no doubt about it. But that still begs the question whether that punishment should be life imprisonment or whether it should be death. Now, here you see, you may have other very heinous crimes, and you don't have in any crime except murder, you don't have the punishment imitating the offence. For example, you don't rape rapists in order to punish rapists. People who throw acid on others do not have acid thrown on them in order to punish them. The punishment is not made to imitate the crime. Those who rob are not robbed in turn. Those who have kidnapped somebody else's child do not have their own children kidnapped as a way of punishment. Punishment is not meant to imitate the crime. It's not, and actually that's because our values are different from the values of the person who has committed the offence. Our values are products of cool, calm deliberation, whereas he may have committed the offence in a moment of passion, anger, temptation, in a moment of weakness, without thinking, with lack of maturity. That's not true of our society when we form our own laws. So we cannot equate the two. Just because somebody has acted in a particular way does not mean that we should too and we should imitate him. If killing is wrong, it's wrong to kill anybody. How can you kill somebody who has killed a person and thereby show that killing is wrong? It does not make sense. And punishment, as I say, in no other case imitates the offence, and it's nobody's case that in these cases justice is not done. So there is no logical reason to say that you need to have the death penalty only, then can justice be done. There's just no basis for that.
What do you have to say to people who support the death penalty in non-homicidal offences such as rape?
The death penalty for rape simplicity, without any homicide being attached to the offence, is extremely problematic and I would say dangerous for everybody concerned, as well as for society. In 1860, when Macaulay was drafting the Indian Penal Code, he thought a great deal, as he is mentioned in his notes, about whether or not rape should be given the death penalty. He mentions in his notes that there are few offences as heinous and as despicable as rape. And yet he chose not to give the death penalty for rape because he said it would incentivize the killing of the victim. If the punishment for rape is the same as the punishment for murder, the rapist would be incentivized to kill the victim and also gain by doing away with the evidence. So rape has to therefore be punished at a lower level. And also on the harm theory, a raped woman is not the same as a dead woman. I mean, that is the Thap Panchayat's view, that a woman whose honor is gone is disgraced as a dead woman. A woman is much more than merely her sexual identity. So therefore to say that the harm done is equal is wrong, is not correct. And the punishment that, to equate rape with murder actually stems from a very reactionary worldview and a very patriarchal worldview. And it's something that should be resisted.
Does the death penalty deter crime more than life imprisonment?
There is not a single study which has proven this. Now, one of the main justifications for the death penalty is that of deterrence. Now, if somebody is going to take away life and claim that it will deter others, then surely it lies on that body, that school of opinion, that school of thought, to prove that death penalty deters murder more than life imprisonment. And not a single study has done that. Studies have shown the opposite, that it does not deter. And my own studies have shown that. But there is not a single study which has achieved any kind of credibility or acceptance anywhere, which has shown that death penalty deters murder more than life imprisonment. According to me, a sentence of 10 years, if it was combined with two other things, certainty of punishment and swiftness of punishment, would be quite enough to deter crime. It's even the most heinous crimes. You don't need harsh, very, very harsh punishment. Because if somebody knew that by committing this particular murder or any death penalty, capital offence, if somebody knew that he would be certainly caught and certainly punished, and for 10 years he would be in jail, and it would happen quickly, I think he would be deterred from committing that crime.
Is the death penalty more cost effective than life imprisonment? Wouldn't it be more beneficial to the taxpayer to execute a criminal rather than pay for his upkeep?
About 10 years ago, the amount of money necessary to keep a person in prison per year was about 10,000. I think it's now about 20,000. Around 3 to 4 people are sentenced to death every year. So if those 4 people were executed, you would have a saving of 80,000, which is just a fraction of what the entire prison budget is. So I don't think in any rational discussion, the fact that you would save 80,000 is a reason to have the death penalty would figure at all.
An Amnesty International report called the death penalty a lethal lottery. Do you think that the death penalty has been whimsically and arbitrarily awarded?
I certainly think so, but that is not quite enough. The Supreme Court has admitted it on more than half a dozen occasions. In judgments, they have said that they have been awarding the death penalty arbitrarily, and the award of the death penalty by the Supreme Court depends more on the personal predilections of the judge than on the facts of the case. This is what the Supreme Court itself has admitted again and again. So yes, it's true, and in fact, this is happening not just in India; it's happening in the States as well. These are human institutions. If they are going to be asked to adjudicate such nebulous and vague concepts, such as rarest of rare, each judge is going to think what is rarest of rare is quite different. Whatever a particular judge thinks will be different from what another judge thinks. It depends so much on your personal philosophy and makeup. And what has happened to you just that day, you should decide what you think is rarest of rare on a particular moment. And therefore, this is going to vary from judge to judge. And when this happens, and the test itself then becomes uncertain, the outcome is going to be arbitrary and capricious. And there's not going to be any even standard across which can be seen across cases.
In various interviews, you've mentioned cases where the police has fabricated evidence that has been relied on by the court while awarding the death penalty. Could you give us an example?
There are so many. I could give you examples from my own personal practice. But let me give you the most sensational example that has come to light of late. It's a case that I have done. It's the case of the Shindes. 6 people were tribals. There was a very heinous crime which had been committed in the Lonavala area, where a family of 5 had been killed and 2 of the women had been raped as well. It really shook society. There was a robbery, rape, murder, and the politicians rushed to the spot, TV crews rushed to the spot. There was a lot of pressure on the police to close the file. They arrested these tribals, 6 of them, and said they had committed the murder. They put them up for trial because the crime was so heinous. I think this often happens in case of heinous crime. The judicial senses get numb. There is not proper scrutiny of evidence. The trial court convicted them, gave them the death sentence. High Court upheld the death sentence. The Supreme Court upheld the death sentence. Subsequently, the Supreme Court even dismissed the review. It was at that stage that the prisoners came to me when they were in imminent danger of execution. It was very difficult for 10 years. I managed to somehow keep them alive, and then due to a change in the law, a technicality, I was able to get the review petition reheard. At which stage, the court calmly considered the evidence, realized this is a completely bogus case, and they moved from one extreme of the spectrum by saying they were not only guilty but they also deserved the death sentence, to the other extreme where they said no, not only are they not guilty, they're also innocent, they've been falsely implicated, they deserve to be acquitted, and they gave them compensation of 5 lakh rupees each. Fabrication of evidence by the police is, in my view, even in ordinary cases, around 80 or 90% of the times in cases, according to me, in 90% of the cases, the police catch the right people. But in all 100% of the cases, they fabricate the evidence. Evidence is routinely fabricated. There are reasons for that. The police is overworked, it's underpaid, it's understaffed, it's undertrained. They just don't have the time, the manpower, the capability, or the motivation to go and gather the evidence. They're not even properly trained, they don't have the skills, they don't have the equipment. It's much easier to fabricate evidence sitting in the police station. Now, this happens, as I say, routinely in every case. They justify to themselves in 90% of the cases saying that these are guilty people, we know they are guilty. And they well may be true, they may have done something, may not have done what the police says they have done, but they may have done something. But in other cases where they are not guilty, the fabrication of evidence can lead to very disastrous consequences. And again, this happens quite often in crimes, in heinous crimes.
Do you believe that the death penalty is being used as a political tool in high-profile cases such as the Nirbhaya rape case or the hanging of Kasab?
Whether you take the Nirbhaya case, whether you take Kasab, whether you take... I mean, Kasab was an extreme case. Whether you take Afzal Guru. See, these are not executions that are taking place in order to ensure that these crimes are not repeated. Afzal Guru was kept in prison for about 6 years. Was Afzal Guru killed in order to deter terrorism in Kashmir? In which case he would have been killed as soon as the Supreme Court pronounced him guilty. Why was he kept alive for 6 years in prison? Afzal Guru was killed for other reasons. At that time, elections were nearing. Pranab Mukherjee had promised Shiv Sena that if elected to the presidency, he would ensure swift dispatch of Afzal Guru. There was political capital and mileage to be had by executing Afzal at that time. Take the Nirbhaya case. Does anyone believe that executing these 4 prisoners is going to make the streets safer for women? Are rapes going to stop? What would make the streets safer for women is implementation of the Verma Committee report. Which of course nobody has bothered to do. The Nirbhaya fund, which was meant for the implementation of the Verma Committee report across the country, is lying unused. So there is no real political will. There is no interest in bringing about a reduction of crime by actual steps, concrete steps. Of course, it's much easier to kill somebody and say we are tough on crime. These are just tinsel gestures which distract people, which are meant to distract people from the main issue and to camouflage the fact that it's complete inaction on the real issues.
In the Kandahar hijack, several civilians were held as hostage till the Indian government freed Islamist prisoners. Keeping a prisoner like Kasab alive could endanger the lives of innocent Indians. What do you have to say to that?
So the argument that keeping Kasab alive would endanger Indian citizens because it would give rise to a hostage crisis like the Kandahar case would therefore recommend that in order to avoid this hostage situation, the prisoner has to be done away with as quickly as possible. Because by keeping him alive, you're creating the possibility of a hostage situation. Now, this scenario of doing away with the prisoner as quickly as possible does not at all allow for a trial or for an appeal. It's not as though a hostage situation is going to wait to be created only after the guilt is confirmed by the Supreme Court. The very arrest of the prisoner gives rise to a potential hostage situation according to this scenario. So therefore, if the hostage situation is to be avoided, the prisoner has to be done away with almost as soon as he is arrested. Because the longer he is kept alive after that, every minute thereafter, he is giving rise to a potential hostage situation. In which case, you cannot have a trial. Because in a case like Kasab, even with the trial going on day to day, morning to evening, it went on for a few years. Thereafter the High Court appeal, thereafter the Supreme Court appeal. You can't have all this. You have to immediately execute the prisoner. Without proving his guilt, you have to execute him first. So this hostage situation argument would require you to do that. Are you prepared to do that? And that too on the say-so of whom? Who is going to say that this person is a terrorist? Because you have not had any judicial adjudication of his being a terrorist or of his guilt. So it is on the say-so of a constable, a police sub-inspector, who has arrested this person and claimed that we found some Lashkar-e-Taiba letterheads and some Pakistani currency in his pocket. It is on the say-so, an unverified and untested say-so of a police officer that are you really prepared to execute somebody without judicial adjudication of his guilt on the mere say-so of a police officer? Do you trust your police so much? Are you willing to put the power of life and death in their hands? The power that you have today given to the judiciary, are you prepared to give it to a police officer and say that in order to avoid this hostage situation, on the say-so of the police officer that this man is a terrorist, let us kill him immediately? If you want freedom, if you want to live in a rule of law society, you are going to have to pay a price. You want a crime-free society? Yes, you can get that. That's easy. You start chopping off limbs, you start killing not only the accused, the prisoner, but also the culprit, but also his family members. You'll put the fear of God. You start chopping off limbs of family members also of people who have committed offences, and you see how the crime rate drops. Are you prepared to do that? Are you prepared to pay any price? So this is what liberal democracies often have to struggle with. We are going to have to pay a price for our freedoms. But to throw away your freedoms completely under the thing that we need to keep our security intact, is to put security at such a high pedestal, is to live in fear. If then the moment you give away your freedoms, you're done for. Your security becomes worthless. Your security without freedom is of no value.
Does the Indian criminal justice system reproduce social inequalities?
It perpetuates them. It depends on them. I would say yes, it depends on them. Your beggary laws. What are your beggary laws doing? They are criminalizing poverty. Your laws against hawking. Your laws criminalizing slums. What are they doing? If a person doesn't have a flat to stay in, where is he going to stay? He's going to stay on the footpath. He's going to stay in a slum. And then you make it a criminal offense to stay in a slum. You're basically making it a criminal offense to be poor. If a person is going to not get a job, if he's illiterate, the only thing he can do to survive is to sell things on the street. If that livelihood is even denied to him and it is criminalized, what are you really doing? You're criminalizing poverty. So certainly we do it all the time, and we do it in the name of environment, we do it in the name of clean streets, healthy living, safety, but we are criminalizing poverty. We do it rampantly. And we do it in order to maintain what we think is a status quo and security.
Do you think that our criminal justice system does enough to accommodate for mental health illnesses like pedophilia, necrophilia?
Pedophilia as mental illness has recently been recognized by DSM. That recognition has not yet reached the law, at least in India, and certainly not even in America. The law is lagging a long way behind it. And not just law, but even law enforcement, medical science is lagging. So for example, if somebody who is having pedophilic thoughts and who's scared about what might happen tomorrow if he allows himself to indulge and given to these temptations, if such a person was to go to the doctor, to a hospital, and tell that doctor, look, this is the problem, I'm having these thoughts, what do I do? Our society, our medical system is not geared to deal with such a situation. So once we understand that pedophilia is a medical problem, then we have to develop systems to be able to deal with it. But we haven't done so, neither has anyone else. We are much more content locking them up in prison or killing them. Our way of dealing with it so far, right now, has been to kill them.
In your experience, have you seen signs of reformation amongst the death row convicts?
Oh my God. Oh my God. Oh yes. Almost without exception, I can tell you. And what I can tell you is I have met more than maybe 1,000 prisoners who have committed homicide. Many of them have been sentenced to death, but many have been sentenced to life. I can tell you, killing somebody is something one does in an irrational moment, in a moment of weakness. Very few have done it in premeditated fashion. But even those that have done it in premeditated fashion, when they were young, have given up and have realized that it is wrong, and they are paying a price for it. I have not yet met anybody who is in prison for homicide who has been unrepentant. And repentance is the first step towards reformation, and the biggest step.